your appearances today. May I take the appearances, please?
May it please the Court, my name is Annie Jang, and I appear with my learned friend, Mr. Kevin Sebastian, for the plaintiffs in both matters. I will speak for 25 minutes on the first question reserved, and my learned friend will speak for 15 minutes on the second question reserved.
Thank you.
Instructed by Mr. James Gunn.
Thank you, Ms. Chang.
May it please the Court, my name is Thomas Dunbabin, and I appear as Senior Counsel for the defendant in this matter. I will be speaking for 21 minutes on the first question reserved, and my co-counsel, Madeline McGregor, will be speaking for 19 minutes on the second question reserved. We are instructed today by Benjamin Durkin.
Thank you, Mr. Dunbabin. Yes, Ms. Jang.
May it please the Court. Your Honours, the first question reserved concerns the validity of Section 6 of the COVID-19 Variant Emergency Act, or COVACT, in its application to the plaintiffs Alfred and Victor. Now, if I may take Your Honours to paragraph 10 of the special case, where Your Honours will find the relevant provision. Section 6, subsection 1, makes it an offence for a person to arrive in Australia having been in a new variant hotspot within 42 days of their flight. And for Alfred and Victor, both Australian citizens, Section 6 will result in their exclusion from Australia for several months. It is our submission that Section 6 exceeds the legislative power of the Commonwealth in its application to the plaintiffs on two grounds. First, as it is unsupported by any head of legislative power, and secondly, as it infringes an implied constitutional limitation on the power of the Commonwealth to deny the entry of the people of the Commonwealth. Turning to the head of power, our learned friends have relied upon the quarantine, external affairs, and nationhood powers, and we submit that Section 6 cannot be supported by any of these heads of power, and I will address each in turn. First, with respect to the quarantine power, we submit that Section 6 is neither supported by its core nor incidental area, noting that the ultimate test for this court is one of sufficiency of connection, as was reaffirmed by the plurality in Spence and Queensland, decided in 2019 and reported in volume 268 of the Commonwealth Law Reports at 355. We rely upon paragraph 58 in particular. Your Honours, may my learned friend and I please dispense with formal citations?
Please do.
Thank you, Your Honour. We submit that Section 6 is not supported by the core of the quarantine power because it simply does not implement a quarantine. And I will now turn to addressing the meaning of that word. In the absence of conclusive authority from this court on the scope of the quarantine power, we rely upon orthodox principles of constitutional interpretation, being that, when ascertaining the meaning of constitutional terms, we begin with the ordinary meaning of the words as they would have borne at Federation. This is not to say that the meaning of quarantine was frozen in 1901, but rather we draw a distinction between the essential meaning of the word, being its connotation, and its application to evolving circumstances, being its denotation, as was noted by Justice Windeyer in Professional Engineers. And it is our submission that the essential meaning of quarantine, as it was understood at the time of Federation, is the detention or isolation of persons to prevent the spread of an infectious disease.
You admit that its denotation may have changed?
Yes, Your Honour.
In what way?
Insofar as quarantine could be applied to diseases that did not exist at the time of Federation, such as COVID-19, or to adapt to, for example, the development and popularisation of aircraft as the primary means of international travel, rather than ships.
For the purpose of your current argument, does the distinction that's sometimes drawn between connotation and denotation make any difference?
It makes a difference insofar as we submit that quarantine, as at Federation, was understood to mean a form of detention or isolation, and we rely upon certain aspects of the convention debates to support this particular meaning.
Might it not be said, though, that in effect what the government is requiring by this law is that people quarantine overseas?
Your Honour, we do not submit that Section 6 is enacting a form of quarantine, as there is no detention or specific isolation of persons. As was reflected in the comments made by the Honourable Richard O'Connor in the convention debates, quarantine it means an enclosure to prevent diseases and general powers of isolation, whereas we submit that the operation of Section 6 is merely a broad one of exclusion and excluding people from entering or from arriving in Australia.
Well, the effect is to isolate them from the country, and that may be a case in which we've seen things evolve because people are no longer arriving by ship, they're arriving by aeroplane, so that they're trying to stop people coming here in the first instance with the disease. So effectively the quarantine station is offshore.
Our submission is that Section 6 does not create any quarantine offshore. And we note that in the convention debates, a broader power with respect to, for example, public health in respect of a contagion or infectious disease arising from outside Australia was rejected in favour of more narrow language of quarantine. And we submit that this narrow language of quarantine refers to a specific form of isolation in the sense of detention, being that Section 6 permits people to roam freely so long as they don't enter Australia, whereas we submit that the restriction of movement that is implemented by a quarantine is more limited.
Ms. Jan, we've probably detained you too long on quarantine. What do you have to say about the next head of power, external affairs?
Yes, Your Honour, and we are content to rely upon our written submissions with respect to the incidental area of the quarantine power in that case. Thus, turning to the matter of external affairs, which is at paragraph 9 of our written case, we submit that Section 6 is not a law with respect to matters or things that are geographically outside Australia. Our learned friends have relied upon this limb of the external affairs power as laws connected to any conduct which took place outside Australia. But our submission is that the law does not bite extraterritorially, but rather only has a legal or direct legal operation within Australian territory. Section 6, subsection 1 makes it an offence to arrive at a landing place in Australia in certain circumstances where the person has been previously in a new variant hotspot. But we say the direct legal operation of the law is within Australia, and that the mischief the Act is dealing with, being the domestic consequences of the KW41 variant, are also domestic consequences.
But might it not be said that this is a law with respect to persons physically external to Australia because it only has application with respect to those persons, albeit at the point of entry?
Our submission is that it is the point at which the offence attaches that is relevant to this particular analysis, Your Honour. So we say that, for example, were someone to board an aircraft in outside Australia that was intended to fly to Australia, but that same aircraft, for, say, fuel purposes, landed in Singapore, the offence would not attach to that particular person. So we say that it is the direct legal operation of the law that is most important here. Your Honour, then turning to the nationhood power, which is at paragraph 10 of our written case. We agree with our learned friends on the general principle that the nationhood power would extend to enterprises and activities peculiarly adapted to the government of a nation and which cannot otherwise be carried on for the benefit of the nation. And we also accept that Section 5139, or the express incidental power, would empower the Commonwealth to make laws with respect to matters incidental to the execution of the nationhood power. However, we submit that the nationhood power could not support Section 6. Firstly, because responding to the KW41 variant, or rather the COVID-19 virus in general, is not a matter peculiarly adapted to the government of a nation. It is clearly within state competence to respond to the relevant public health threat, and indeed, as per paragraphs 5 to 7 of the special case, It was the state's hard lockdowns that resolved the KW41 outbreaks in late 2021.
Do you accept in principle that a pandemic is of its nature something that might engage the nationhood power and that it's a threat to the nation which calls for a national response?
Potentially and to an extent, Your Honour, but we submit that merely being national in the sense that it affects all persons in the nation is not sufficient to enliven the nationhood power.
But isn't one difficulty that state boundaries are meaningless from the virus's perspective? Can't be contained by state viruses necessarily.
It is our submission that the restrictions imposed by states have shown a great effect in restraining the intrusion of the virus or the entry of the virus into particular states, and that the states have shown competence to respond either in the form of hard lockdowns or in border restrictions themselves.
Again, one might say at great economic cost.
That may be the case, Your Honour, but it is our submission that it is not part of the judicial function to reflect upon the policy choices made by the states or the Commonwealth, and that while it is within the capacity and resources of the states to respond to KW41, the response is not one that is peculiarly adapted to the government of a nation.
No,
So,
my point, sorry.
so do you say that a provision in terms of Section 6 could be enacted by every state in the Commonwealth?
We submit that it would be within the plenary powers of the states to enact a provision of that kind or to make other responses.
Some states could choose to enact it. Some states could choose to enact it in relation to some overseas hotspots, and some states could choose other overseas hotspots. Wouldn't we be turning our international relations over to state parliaments in those circumstances?
No, Your Honour. We submit that firstly that the states could also engage in other measures as they have, but insofar as the states could impose differing travel restrictions or border restrictions, we submit that this does not necessarily affect Australia's international relations, nor is the potential consequence on Australia's international relations a necessary element of whether a law could be supported by the implied nationhood power.
Now, we'd better hear from you on the last point, which is the implied constitutional freedom point, I think.
Yes, Your Honour. And noting that this begins at paragraph 12 of our written case, we submit that even if this court finds that Section 6 is supported by a head of power, it is nonetheless invalid in its application to Alfred and Victor, as they are protected by an implied constitutional limitation on the power of the Commonwealth to prevent the people of the Commonwealth from entering and residing in Australia. We note that our learned friends accept at paragraph 21 of their written submission that there is a common law right of re-entry, and they note that common law rights could present a guide to the implication of constitutional freedoms, although they wouldn't of themselves present a foundation. We say that the freedom that we urge the court to recognise does have constitutional underpinnings, and our argument has three parts. Noting that we agree with our learned friends that a novel constitutional limitation must be apparent in the text of the Constitution or practically necessary to uphold the constitutional structure, we submit that the text of the Constitution and its structure create and enshrine a continuing concept of the people of the Commonwealth, and this is at paragraph 14. Secondly, that to give effect to other guarantees and freedoms in the Constitution, it is necessary that the people of the Commonwealth be able to enter and reside in Australia. And thirdly, that the limitation is a necessary incident of the constitutional relationship between a sovereign and a non-alien. And I will address each of these points in turn. On the textual factors, Your Honours, we submit that there are numerous mentions in the Constitution of the concept of the people, and we submit that these create and enshrine a constitutional concept of the people of the Commonwealth or of an Australian political community. And we submit that this community is not only a political but a territorial community, as was adverted to in Love and the Commonwealth by both Your Honour Justice Gageler at paragraph 129 and by Justice Edelman at paragraph 438. It is our submission that the members of the people of the Commonwealth, as making up the members of the body politic of Australia, are all those persons who are not aliens, and rely upon 4 members of this court in Love for that particular proposition. Thus, it is our submission that all persons who are not aliens are members of a political and territorial community which the Constitution envisages will exist and continue, such that Parliament could not legislate so as to destroy it or sever its ties with the Australian territory. We would here also draw a distinction between our submission and any concept of constitutional citizenship. We accept that, pursuant to the aliens and naturalisation power, and potentially other powers, Parliament is able to determine who is or is not a member of the political community. But our submission is that membership of that community has constitutional consequences, and we submit that it is perfectly in line with current constitutional jurisprudence, such as in relation to the franchise in Roche. We submit that similarly to that limitation, our limitation has sufficient constitutional underpinning. Turning to our second.
Sorry, can I ask, are you positing an absolute right to return, or is it subject to qualifications? For instance, in this case, this type of scenario, could Parliament have said citizens have to get vaccinated and be COVID-free, having had a test in the last 24 hours before they board a plane? Can there be some limits on the right to return?
Yes, we accept that the limitation is subject to some justification testing, and our submissions on this point begin at paragraph 18 of our written case. And we also note that there is current legislation and Commonwealth regulation requiring persons who are purporting to enter Australia to first provide evidence of a negative COVID test. And we submit that that sort of regulation, as well as Section 6, are subject to this proportionality testing.
What do you say are the principles on the basis of which constitutional implications can properly be drawn?
We submit that constitutional implications may be drawn where apparent in the text or structure of the Constitution, or practically necessary to uphold the constitutional structure, as was held by Justice Brennan in McGuinty. Turning then to the practical necessity point, we submit that the limitation we urge the court to recognise is practically necessary to ensure the effectiveness of other rights and guarantees that are express or implied in the Constitution. And some examples we provide are the freedom of interstate trade, commerce and intercourse protected by Section 92 of the Constitution, the right to use the navigable waters of the Commonwealth for the purposes of trade and commerce derived from Sections 98 and 100, as well as rights of suffrage per Sections 7 and 24. We submit that to have the benefit of such freedoms and privileges, it is practically necessary that the people of the Commonwealth be able to enter and reside in Australia. So, for example, in order to use the navigable waters of the Commonwealth or to have the benefit of those navigable waters, persons must be able to access the navigable waters.
What navigable waters are you speaking of?
We're speaking of the Parliament's ability per Section 98 to regulate the navigable waters of the Commonwealth, as was raised, as well as the potential right that was suggested by Quick and Garran in their annotated commentaries. So this includes, for example, rivers per Section 100.
But we're a long way, aren't we, from people who are currently in Poland and who want to return to Australia? Surely it's not to go boating on the Murray.
Your Honour, we do not submit that the limitation provides a right to individuals to engage in particular activities, but we submit that the ability and the exercise of these freedoms requires a general limitation on the ability of the Parliament to deny the entry of the people of the Commonwealth whatever their particular purpose for entering Australia. We also would note here that our learned friends submit at paragraph 19 that where the Constitution protects movement, of paragraph 19 of their written case, that if the Constitution protects movement, it does so expressly, such as by section 92. Our submission is that section 92 does not by implication preclude any other limitations or constitutional limitations relating to movement. We submit that the limitation we urge the court to recognise has an independent sphere of operation to section 92, and contrary to our learned friends, would not render section 92 otiose because of its independent operation. Turning to our third point with respect to the relationship between the Commonwealth and non-aliens, we submit that the limitation is practically necessary as an incident of the constitutional relationship between the Commonwealth as a sovereign state and its people, as it is a premise of the Constitution that it envisages the Commonwealth as a sovereign state with an international legal personality, and the limitation is a necessary incident of the constitutional relationship between a sovereign state and its members. Noting that Justices Gummow, Hayne and Hayden in Singh suggested that as a result the sovereign state owes certain obligations to its members, among them possibly the ability to enter. If Your Honours do not have any further questions on this particular point, I would move to the infringement provision of the analysis.
Could I just ask this question? Is what you're putting tantamount to saying that there is a sort of constitutional status of citizenship, so that citizens enjoy some constitutional protection that Parliament can't take away from them?
Not a constitutional concept of citizenship as previously been considered by this court, being that we do not submit that there are particular people who the Commonwealth could not treat as aliens, or that in that respect, but we do submit that the Parliament's statutory choice to grant someone citizenship, which it may exercise under the Constitution, may still have particular constitutional consequences, so as it did for the franchise in Roche. Your Honours, if Your Honours do accept our submissions in this regard, we submit that Alfred and Victor, as citizens, are not aliens and therefore members of the people of the Commonwealth, and we submit that in this respect they are protected by this constitutional limitation. So on the matter of infringement, as Your Honours note, we have already accepted that the limitation is not absolute and subject to justification. Now, as our learned friends have not made detailed written submissions on this matter, I am content to rely upon our written argument with respect to the matters of burden, purpose and suitability at paragraphs 18 and 21, and turn to necessity and adequacy. And it is our submission that structured proportionality is an appropriate analytical tool to assist with this justification testing. However, we do accept that we do submit that on any other test, the law would similarly be found to be invalid. With respect to necessity, Your Honours, our submission is that there is an obvious and compelling alternative measure that the Commonwealth could have implemented that would be equally effective whilst imposing a substantially lesser burden on this freedom, as the law could have prescribed that a person must not have been in a new variant hotspot within 21 days of their flight, which is, per paragraph 4 of the special case, the longest possible incubation period of the relevant virus. We submit that this alternative would be as capable of achieving this purpose because persons, as Your Honour Justice Mashinsky already noted, persons returning to Australia must submit evidence of a negative COVID test. And it is our submission that a period which coincides with the maximum incubation period of the virus would permit persons to be tested for COVID-19 with sufficient certainty. This would halve the potential burden on the relevant, on this guarantee, on the constitutional guarantee with respect to the people of the Commonwealth, and further would permit all persons who could submit evidence of their negative COVID test to enter Australia after merely 21 days rather than 42. Your Honours, turning then briefly to our final submission with respect to adequacy, we would note here that Section 6 does not provide any significant exemptions that have a discretionary element. We note that this provision does have some exemptions, but we submit that its application to Alfred, who is a sole citizen of Australia, is particularly illustrative of the extent of the burden it places on this relevant freedom. As it has stranded Alfred in Poland without, with his visa set to expire and no lawful right to remain in that particular country. And we submit that the lack of exemptions for exceptional circumstances such as these is relevant and indicates the excessive burden that is placed on the relevant guarantee. Your Honours, we would also submit that to the extent that the law imposes substantial criminal penalties, including imprisonment and substantial fines, it also presents a particularly excessive burden on the freedom.
Would you maintain that submission even if it were only a 21-day period of time within which the person were required to travel somewhere and remain there, which was not a variant hotspot?
No, Your Honour. We submit that would indicate, insofar that would indicate that it presents a lesser burden, at least by reference to the period. We do note that the lack of exemptions may still be relevant to the court's analysis of the adequacy of the law, however. Your Honours, I believe that my time has expired. May I be of any further assistance to the court?
You have been of great assistance, Ms. Jang. Thank you. We don't require hearing from you further. Do we move here to Mr. Sebastian? Thank you, Ms. Jang. Yes, Mr. Sebastian.
May it please the court. In relation to the second question reserved, the plaintiff submits that Section 8 of the Cove Act is invalid, as it infringes the implied intergovernmental immunity outlined in Melbourne Corporation. Now, the principle in that case requires consideration of whether impugned legislation is directed at the states, imposing some special disability or burden on the exercise of powers and fulfilment of functions of the states, which curtails their capacity to function as governments. Our submission on the second question is that the Commonwealth law here contravenes the Melbourne Corporation principle on the following three bases. First, because Section 8 impermissibly directs state employees to participate in the administration of a federal legislative scheme. Second, because it interferes with the state's ability to manage and control their public health officers, a crucial government function. And third, because it singles out the states and imposes a special burden or disability on them, not imposed on persons generally. And I will address each of these submissions in turn, but just before I do, I would draw Your Honour's attention to the nature of Section 8, and that is that it is an administrative discretion. And so the approach generally to be taken in assessing such a discretion, as noted by 5 justices of this court in Palmer, is that when assessing the constitutional validity of such discretions, the court is to make a determination by reference to the scope of the authorising provision itself, and here that is Section 8, rather than any particular exercise of the statutory power it confers, that is, the direction issued to Ms. Arnold and others on the 6th of February 2022. And so for context, I will just take Your Honours to the administrative discretion provided for in Section 8 now, which can be found at paragraph 11 of the special case. And as Your Honours will see, Section 8 subsection 2 provides that the Minister may direct a state public health officer to be present at an airport to assist with the administration of the Cove Act. Now, a state public health officer is defined by Section 3 of the Act as any authorised officer under the Public Health and Wellbeing Act, other than the Chief Health Officer. And the relevance of authorised officers will be outlined more fulsomely later in my submissions. But at this point, the court should take notice of the fact that the Commonwealth is not limited in the exercise of this discretion in terms of the number of authorised officers it may direct to the timeframe it may allocate those authorised officers to assist with the administration of the Cove Act. And that is really quite a broad discretion on the Commonwealth Minister to require state public health officers to step away from performing crucial public health functions and instead assist in the administration of a Commonwealth Act. And that really disrupts the coexistence of the Commonwealth and state governments as separate entities, really the fundamental principle underpinning Melbourne Corporation.
Do we know when it is or the circumstances in which a human biosecurity emergency declaration may be made? And would that have any impact on your argument? And how long such a declaration may endure for without renewal?
Your Honour, there is a limitation to Section 8 in that a human biosecurity emergency declaration must indeed be in force.
Yeah.
And Section 443 of the Biosecurity Act provides that the Governor-General may make such a declaration. But in our submission, this is of no comfort for two reasons. First, this is really precisely the time at which authorised officers are most needed. Authorised officers have certain emergency powers during a public health emergency provided by Section 199 of the Public Health and Wellbeing Act and listed in Section 200 of that Act. And to a large degree, a state of emergency declared by the states enabling the additional exercise of those executive powers will be coextensive with the presence of a biosecurity emergency declaration. But second, upon the facts disclosed by paragraph 2 of the special case, this declaration has been renewed every 3 months for a period of 2 years, and I think the court can take judicial notice of the fact that this shows no sign of letting up with respect to the KW41 variant. And so this is not functionally a discrete time period that has afforded any real restraint. I'd turn now then to our first submission on this question, and that is that Section 8 is invalid because it allows the Commonwealth to unilaterally direct state employees to participate in the administration of a federal legislative scheme. Now, in this regard, Your Honours, we submit that Section 8 operates contrary to really the fundamental principle underpinning the Melbourne Corporation case, as it operates to allow the Commonwealth to control the states. So in Melbourne Corporation, Justice Dixon stated at page 81 that the considerations upon which the state's title to protection from Commonwealth control arise not from the character of the powers retained by the states, but from their position as separate governments in the federal system exercising independent functions. Now, this is an essential feature of the Australian federal system of government. And what Section 8 does is it permits a Commonwealth Minister to control state statutory office holders, requiring them to exercise designated functions for the Commonwealth rather than for the states. In essence, it overrides the state's authority over its own personnel.
Well, we have to be very careful about this, don't we? If we go back to the engineers case, we were concerned there with the federal regulation of the terms and conditions of employment of people who were state public servants. What's the difference between that scenario and the scenario in the present case?
Your Honour, our submission is that terms and conditions do not equal co-opting. So in terms of regulating the terms and conditions by which state employees may be subject to under Commonwealth legislation, that does not go so far as to essentially co-opt state authorised officers for Commonwealth ends as we have in Section 8 here. Now, the principle that we urge this court to adopt in this regard was held to apply in reverse to state legislation imposing state functions on Commonwealth employees in the Queen against Hughes. And at paragraph 31 of that judgment, Their Honours wrote that a state by its laws cannot unilaterally invest functions under that law in offices of the Commonwealth. And we submit that this principle equally applies to the Commonwealth unilaterally investing functions in state offices as it has done here. Now, of course, the plaintiff accepts that this, we say, necessary reflection of the Melbourne Corporation doctrine has not been applied in precisely this formulation in Australian law. However, this principle has been accepted in the United States as a consequence of the federal system of government. And those principles, we say, really conform to the key principles underpinning Melbourne Corporation. So, for example, in Prince in the United States, the Supreme Court of the US accepted the proposition that a federal law cannot require state officials to assist with the enforcement of federal statutes, in that case, the Brady Handgun Violence Prevention Act. And the reasoning in that case, written by Justice Scalia for the majority, is really quite reminiscent of the principles in Melbourne Corporation. His Honour wrote, "It is an essential attribute of the state's retained sovereignty that they remain independent and autonomous within their proper sphere of authority." Now, similarly, Chief Justice Latham at page 55 of that judgment wrote, "The Constitution is based upon and provides for the continued coexistence of Commonwealth and states as separate governments, each independent of the other within its own sphere, and that the subordination of either to the other is inconsistent with a federal system." Sorry, Your Honour, I'm having difficulty hearing you.
Under the federal system, it is perfectly permissible, isn't it, for the Commonwealth Parliament to confer federal jurisdiction on a state court and thereby to impose a duty on state judges to administer and adjudicate upon matters arising under Commonwealth law. How is that different from the law we're concerned about here?
Well, there are various provisions in the Constitution that authorise the imposition of Commonwealth duties on the state, its institutions and its officers. Your Honour has rightly identified, for example, Chapter 3. There is also Chapter 120, which deals with the incarceration of federal prisoners in state prisons. However, we say that where there is no consent and where there is no contraindication within the Constitution, then none of the parliaments within the Federation has the power to unilaterally impose official duties or functions on another government or its officers, employees, or instrumentalities. And so essentially, because there has been no consent in this case, and because there is no constitutional underpinning for the delegation of these duties or functions, Section 8 must be held invalid on the basis that it directs state employees to participate in administering the Cove Act. I'll turn now then to our second submission on this question, and that is that Section 8 impermissibly restricts the state's ability to manage and control their personnel, a significant curtailment of the state's capacity to function as government. Now, the state's ability to engage the personnel it needs is a constitutional function of vital importance, as was recognised by this court in Re AEU and the ILO case. Now, in Re AEU, 6 justices of this court recognised at pages 232 to 233 that consequently critical to the state's capacity to function as a government was the government's right to determine the number and identity of the persons whom it wishes to employ, and for higher level employees, the government's ability to set the terms and conditions of their employment. Now, we submit that the broader principles underpinning that reasoning in Re AEU are of particular relevance to Section 8, and those principles are twofold. First, we submit that the court recognised that it is for the states to determine how many employees they need and who they are, because the state must be able to engage the personnel it requires to fulfil its governmental functions. And second, the court recognised that there are some personnel whose functions are so critical to the machinery of government that the state must be able to exercise an even higher level of control over those employees. And so on that basis, we submit that Section 8 is contrary to the implied intergovernmental immunity because it strikes at the heart of both of those underlying principles.
Might I ask, though, that is the level at which the employee is employed relevant to this question, because there is an exception made in the case of the state chief health officers. So it only applies to those below the chief health officer. Is that relevant? And if so, why?
Your Honours, our submission is that it is not in this case. And that is because we note that the language of Re AEU is really tied to the specific vaccine issue in that case, particularly with a focus on industrial relations between the Victorian state and various arms of the Victorian public service on issues such as award wages, redundancies, and employment benefits and things of that ilk. And so on that basis, there's a particular focus on terms and conditions of employment for higher level employees versus this number and identity for all employees. And of course, we accept the court's reasoning around those issues as a matter of industrial relations. But we say that really the principle underpinning that is that there will be some employees who are so critical to the state's functioning that they must be afforded a high level of protection from Commonwealth control. And we say on that basis that authorised officers under the Public Health and Wellbeing Act are such employees. Your Honour, that is particularly so in the context of the public health emergency before disclosed in the special case. And so on that basis, we submit that public health employees with specialised skill sets are particularly critical to the functioning of state governments during a public health emergency. Noting that my time is about to elapse, if I could just request an additional minute to finish this point.
Yes.
That is 1 minute, yes.
Thank you. And so in particular, we note that authorised officers under the Public Health and Wellbeing Act are given broad-ranging executive powers under Part 9 of that Act, and indeed, as I noted earlier, Section 199 of that Act further provides that authorised officers may exercise emergency powers, which include under Section 201D the power to give any direction that the authorised officer considers is reasonably necessary to protect public health. And so contrary to my learned friend's submissions at paragraph 32 of their written case, these executive powers are not so limited, but rather essential to the functioning of the state government. And so we submit that the function of public health personnel are therefore sufficiently critical to the state government's functions that the state should be able to determine all aspects of their employment, including the task that they are to undertake on a day-to-day basis. And Section 8 simply curtails that ability.
Very good. Thank you for that, Mr. Sebastian.
May it please
we move now to Mr. Dunbabin.
May it please the court. The Commonwealth has enacted the Cove Act as a measure to ameliorate significant risk posed by the KW41 variant. The nation is indeed faced with a time of crisis due to this variant, as it poses a significant threat to Australia's health and economy. We submit that Section 6 of the Cove Act is validly enacted, as it is supported by either Section 51(9), the quarantine power, the incidental nationhood power within Sections 51, 39 and 61, or Sections 51, 29, the external affairs power of the Constitution. I will address these heads of power in the same order as the plaintiff today, before turning to the submission on a right to return. We would submit that Section 6 is not invalid by reason it is contrary to an implied right to return, as such a right does not exist. It lacks a textual, structural, or principled foundation. I would turn first to the quarantine power. Your Honours, the issue at contention here in the present case is really one of definition. The plaintiff has put forward a definition of quarantine as being detention or isolation that is limited to Australian territory at paragraph 5 of their written statements, at least in respect of the core subject area of the quarantine power. However, Your Honours, we say that there is a broader interpretation of quarantine that has been identified and should be adopted by this court. In the case of Gurner, whilst considering issues around freedom of movement, this court did unanimously consider that the essence of quarantine is, and I quote, "The actual movement of persons is restricted or altogether prohibited." And this broader statement finds historical basis as well. Quick and Garran, in their annotated constitution, refer to the quarantine power as comprehensive enough to cover any forced stoppage of travel or transit. Whilst this court has never directly interpreted the scope of the quarantine power, it should be interpreted with all the generality which the words admit, and the court should, in accordance with the Jumbunna principle, where there is uncertainty as to a definition, lean to the broader interpretation.
So might quarantine then mean, on your interpretation, really isolating a person from the broader Australian community, however that is affected?
Your Honour, it would have to be isolation for the purpose of preventing the spread of a disease, and we
Yes.
accept that. The broad essence of quarantine, we would submit, is to restrict or prohibit the movement of persons who pose a disease risk, and not to merely isolate those who are diseased. Any argument that quarantine extends only to forced isolation should be rejected. And Your Honours, since Section 6 of the Cove Act does that, in prohibiting the transit of those who are at risk of spreading the disease, the KW41 variant, into Australia, we would submit it is sufficiently connected to that core subject area and that core definition of quarantine.
So, Mr. Dunbabin, you would say that if a ship is carrying a diseased cargo, the power would allow the Coast Guard officials to be authorised to turn the ship around.
Your Honour, in effect, yes, that would serve as a form of quarantine on our submission. Unless Your Honours had any further questions on the quarantine power, and I seek also to rely on our written submissions in regard to the incidental aspect of that quarantine power, I may turn now to the external affairs power. Your Honours, we submit that Section 6 of the Cove Act is supported by the geographic externality limb of the external affairs power. The plaintiffs have submitted that a law is properly characterised, the current law here is properly characterised as only having legal operation within the Australian territory, as that is the point where the offence attaches. But with respect, Your Honours, the geographic externality limb, we say, has a broader application. In the case of XYZ, at paragraph 30, Justices Gummo, Hayne and Crennan said, and I quote, "The word external is precise and is unqualified. If a person, place, matter or thing lies outside the geographic limits of the country, then it is external to it, and it falls within the meaning of the phrase external affairs." And Chief Justice Gleeson agreed with this. Your Honours, insofar as the Section 6 of the Cove Act regulates the conduct of those overseas, and indeed we submit the provision is dependent upon overseas conduct, it is immaterial that the offence itself is not committed until a person enters Australian territory. It is enough that the provision regulates conduct which is concerned with movement overseas or in and out of Australia. Your Honours, the plaintiffs have attempted here to distinguish this case from the case of DL and Director General, which was cited in the case of XYZ at paragraph 35, where in that case of DL, 6 judges of the court said, and I quote, in reference to regulations concerning the movement of abducted children between Australia and the USA, the subject matter of regulations, the return of children abducted from Australia and the return of children abducted to Australia, is concerned with the movement of children between Australia and places physically external to Australia, and thus it falls within the phrase external affairs. Your Honour, on our submission, a central component of Section 6 is reliant on conduct that has occurred overseas. And to that extent, it should be supported by the geographic externality limb of the external affairs power. Unless Your Honours have any further questions on the external affairs power, I may turn now to the implied nationhood power. Your Honours, in responding to the KW variant national crisis, we say that Section 6 of the Cove Act is supported by the nationhood power because it addresses an issue which is peculiarly adapted for the government of a nation and could not otherwise be carried on for the benefit of the nation, that being the test espoused by Justice Mason in the AAP case. Your Honours, a starting point is the court's holding in the case of CPCF, where it was noted that there is an implied executive nationhood power to respond to national emergencies. And I quote there from paragraph 150. Your Honours, this follows from the court's holding in Pape, in paragraph 233, that the executive government is the arm of government capable of and empowered to respond to a crisis. Firstly, Your Honours, as a matter of initial bar, as it were, the fact that the legislation is coercive does not mean that it will fail this test, as the plaintiffs have submitted. Indeed, Chief Justice Mason and Justices Dean and Gaudron said in Davis, page 99, and I quote, "The implied legislative power, as well as the incidental power under Section 5139, enables Parliament to enact coercive laws." And they pointed to the case of Burns and Ransley. The case of the Queen and Sharkey may also be on point there.
What might be the rationale for saying that it doesn't apply to extend to coercive powers?
Your Honours, I think that may be to do with a broader concern about the scope of Section 61 and the depths of the executive power, as it were. However, the breadths and depths of the executive power have been held to be quite wide and quite deep, as it were. For example, the Tampa case comes to mind as a valid incident of the executive power to in effect uphold coercive actions.
Can I check with you as well? I think the focus by senior counsel for the plaintiff was upon the pandemic.
Yes.
Whereas do you rely upon not only the existence of the pandemic, but its economic and other implications as a basis on which to support this under the nationhood power?
Yes, Your Honour, and with respect, we would rely on those factors as well. The facts before us show that what we have here is truly a national crisis which has touched every state. As Your Honour previously and rightfully pointed out, it is the fact that the virus has no respect for state borders. Indeed, the complex nature of the international travel system and the complex nature of the interstate travel system mean that there is a danger in leaving it to the states to manage, in that the state approaches will not achieve the same goal as the Commonwealth, by the simple fact that state approaches will always be burdened by the weakest link, as it were. There is truly a need for a uniform approach here to stop the entry of this variant into Australia. If this variant were to infect one state, then, as we have seen, it can quickly affect every state, which leaves the states with the difficult task of imposing restrictive legislation such as lockdowns, which have severe effects both on the economy and the mental health of the population, as was noted in the special case.
Now, it was put against you that we should engage in some form of Germanic-style structured proportionality analysis. Is that what you would have us do?
Your Honour, with respect, structured proportionality may be a useful tool of analysis, but we would submit that on any form of proportionality testing, whether it be structured proportionality or perhaps the more widely used reasonably and appropriately adapted standard, the legislation here would be adapted to that purpose. I think the core point of contention between the two parties, as I see it, is with regards to the 42-day imposition that this legislation imposes. And the plaintiffs contend that 42-day imposition is disproportionate, given that it is an agreed fact that the incubation period of the KW41 variant is between 14 and 21 days. Your Honours...
But the question of whether this is proportionate might be broader than that. Other alternatives that come to mind would be allowing citizens to return and having a very, very robust quarantine facility when they arrive, but not preventing citizens to return to the country. So how do you justify this type of measure?
Certainly. And there's 2 points I'd raise in response to Your Honour's question. Firstly, on the facts, on the special case before us, we note at paragraph 8 that there are, as of yet, no further quarantine stations which have been built within the nation. And at previous paragraphs, it is mentioned that the hotel quarantine system here in Australia has, as of yet, been insufficient to control the spread of the virus. And secondly, and perhaps more principally, Your Honours, we submit that here, essential epidemiological information pertaining to the KW variant is currently unknown. And this includes the severity of the disease, its transmissibility, and, for example, the time the virus could survive external to a host. And the evidence here should not be taken at its lowest. The evolving scientific understanding of this new virus means that there must be an appropriately cautious response viewed in light of the severity and transmissibility of the variants and the outcomes which may flow from community transmission. And indeed, in the case of Palmer, in upholding COVID-19 related state border closures, Chief Justice Kiefel, with Justice Gagler and Keane, said, and I quote, "Because of the uncertainties about the level of risk and the severe or even catastrophic outcomes which might result from community transmission, a precautionary approach should be adopted." That is, the Parliament should both adopt a precautionary approach here and has rightfully done so, and the court should be, in part, deferential to what is a well-informed public policy choice. Your Honours.
So you contend that it is the uncertainty rather than the current state of medical knowledge that renders this reasonably appropriate and adapted to the legitimate.
Yes, Your Honour. On our submission, say
purpose.
that sorry, Your Honour. Yes. On our submission, we say that the paucity of knowledge surrounding this variant, as it currently stands, means that the Commonwealth has taken what is a precautious approach, no doubt, but a precautious approach which can be justified in that context. Unless Your Honours had any further questions on the nationhood power or indeed heads of power more generally, I may now turn to the right of return argument before this court. Your Honours, as the plaintiff noted, the overarching test of the court here is that any right to be drawn in the Constitution must either be securely based in the text of the Constitution or necessary to give effect to the structure of the Constitution. Your Honours, as a starting point, the plaintiffs have submitted that the people of the Commonwealth, as enshrined in certain sections of the Constitution, established, as it were, a constitutional class of non-aliens, at paragraph 14 of your written submissions. In response, we say there are two things to note on this point. Firstly, these sections do not refer to the people as a term of art and must be understood in their individual contexts. For example, the people referred to in the preamble of the Constitution are the people of the various colonies, not yet the Commonwealth, and in a technical sense, the people there is confined to the electors who voted for the referenda on the Constitution Bill. Other constitutional sections, including Section 7 or 24, are concerned only with electors, a group which is not synonymous with citizens or non-aliens of this country. Indeed, many non-citizens can vote in federal elections, and Parliament can validly disenfranchise classes of persons. Secondly, Your Honours, we would question that a class of non-aliens exists at all. Indeed, as the majority held in Jakuti, the aliens' power encompasses both power to determine who is and who is not to have the legal status of an alien, and power to attach consequences to that status, that being at paragraph 12. Your Honours, being the people of the Australian community, or the people of the Commonwealth, or members of the Australian community, is not enough to ground such an implication on our submission. High Court jurisprudence even indicates that even very long-term residents of Australia who do not hold statutory citizenship, but who are members of the Australian community in the sense that they share all or many of the substantive rights of citizens, such as a right to vote, can qualify as aliens for constitutional purposes, that being the holding in Jakuti or cases such as Shaw and Kochi. But in any case, Your Honours, a right to return does not extend to such a class, as there is no principled basis for such a right. The plaintiffs firstly rely on cases such as Air Caledoni, which concern a common law right to return. And indeed, in the case of Love, Your Honour Justice Gagler at paragraph 94 did clearly state that this right referred to in Air Caledonia was the common law right of return. However, Your Honours, common law rights can only be integrated into the constitutional structure insofar as the text and structure will allow. The plaintiffs contend at paragraph 15 that the exercise of certain freedoms requires that the people of the Commonwealth be allowed to enter and reside in Australia, pointing to, for example, section 92 of the freedom to access navigable waters. However, it was this line of reasoning which was in essence rejected in this court, but in Gurner, where the court held that it was not necessary to imply a broader freedom of movement to protect others' freedoms, such as section 92, or indeed the implied freedom of political communication. Indeed, Your Honours, to use the language of Gurner, an implication of a broader right to return would render otiose the textual delineation of a protection of interstate commerce as enshrined in section 92. Further, Your Honours, the implication of such a right to return is broadly inconsistent with the general rejection of constitutionally protected rights. A quote from Justice Mason in ACTV. The Constitution was drafted on the assumption that there was no need to incorporate a comprehensive Bill of Rights in order to protect the rights and freedoms of citizens. And in this sense, our Constitution is distinguishable from constitutions such as the US Constitution, which enshrines a right to return in the 14th Amendment, or the Constitution of Canada, where in Section 6 of the Canadian Charter of Rights and Freedoms entrenches a right to return.
And why was that constitutional choice made? What underlies it? In what does the Constitution trust then to protect
Your Honours,
the position of citizens and non-citizens present?
The Constitution trusts in responsible government to protect the rights of citizens. It trusts in parliamentary supremacy to protect the rights of citizens, and the Parliament is, of course, elected in our free elections through our system of representative and responsible government. So the framers intended that that system would protect the rights of citizens. Your Honours, in any case, this right, even if the court was to find such a right does exist, it would not be an absolute right. And like any other implied right, it could be validly burdened. Noting your time, my honours, I think here I will rely on the submissions I've made earlier about how this law is reasonably and appropriately adapted to the purpose at hand. And unless your honours have any further questions, I might conclude my submissions on section 6 here.
Thank you, Mr. Dunbabin. And that concludes your part of the argument, as I understand it.
Yes, Your Honour. May it please the court.
Thank you. Well, we move to Ms. McGregor at this stage. Ms. McGregor, are you with us?
Yes, Your Honour. Apologies, I had some delays in my connection.
Please proceed.
Thank you, Your Honour, and may it please the court. Your Honours, the argument made by the plaintiffs today is reminiscent of the reserve powers doctrine reasoning by claiming that a state has exclusive power over its personnel and health management, reference or reliance on US case authorities. This reasoning was expressly denied by this court in the engineer's case and has remained rejected ever since. Your Honours, the engineer's case held that the Constitution is interpreted by reference to its text and structure, and not by reference to any powers historically accorded to the state. It is against this background of engineers that the court fashioned out a very limited exception in the form of the Melbourne Corporation Principle, an implied intergovernmental immunity. This exception operates to protect against Commonwealth legislation that interferes with states at the higher levels of government and against essential organs of the state. Your Honours, the inquiry established by the Melbourne Corporation Principle is whether a law substantially curtails or interferes with a state's constitutional functions. And I note that our learned friends are in agreement with this test. And as Chief Justice French held in the case of Clark at paragraph 34, this involves a multifactorial assessment. Section 8 of the Cove Act enlists a handful of state officers to assist in the checking and monitoring of international arrivals at airports. And this is not inconsistent with the Melbourne Corporation principle. And Your Honours, will point to 3 factors for this proposition.
Just sorry to interrupt you there, but you say a handful, but might it be more than a handful? I don't think it limits the extent to which Section 8 might be utilised, does it?
Your Honour, Section 8 does limit the extent in the sense that it is only applied to public health officers as opposed to a broader subset of the state's public service, and is in that sense that I use the term handful, Your Honour. Turning to these factors pointing to validity in this case, the first is that Section 8 does not burden or curtail any state constitutional functions. And in addressing this point, I will respond to our learned friend's contention that regulation of state personnel amounts to a state constitutional function. The second factor, Your Honours, is that any burden, it fails to meet the threshold of significant or substantial required by the Melbourne Corporation test. And third, that Section 8 in practice does not curtail the choice of the Victorian government, another significant factor pointing to validity. Your Honours, before I address these factors, I'd first seek to note that the plaintiff placed reliance upon an argument of Section 8 imposing a discriminatory burden, in particular in its form in singling out states as opposed to a general application. And with respect to this, Your Honours, it would be helpful to turn to paragraph 238 of the Queensland Electric Commission case, in which, and I quote, this court held, the discriminatory operation of the Act cannot be justified as itself coming within the intended scope of the Melbourne Corporation doctrine, especially where the doctrine is not one of significance to the maintenance of essential organs of government. And Your Honours, as I will now outline, Section 8 does not burden any constitutional functions of the state. Turning to this first factor in this multifactorial analysis, that is, Section 8 does not burden essential constitutional functions of the state. The Melbourne Corporation principle protects constitutional functions, and this court in the case of Austin held what is a constitutional function to be the maintenance of an independent executive, legislature and judiciary as provided by Australia's constitution. And we submit that Section 8 does not burden any of these essential branches of state government.
But does it need to be a constitutional function to come within this principle? In the midst of a pandemic, one might say that the people who work in the health department are very important people in terms of the capacity of the state to function as a government.
Your Honour, we would certainly accept that public health officers in a time of pandemic play an important role for the state, but with respect to the Melbourne Corporation doctrine and assessment, they are not important in that relevant constitutional sense. And Your Honour, it would not make sense, given the conception of the Melbourne Corporation doctrine, which protects entities as enduring or continuing concepts, to use the language from Austin, to adopt a fluctuating test where what is important or going to essential functions of the state as being capable of fluctuating in a time of crisis.
Ms. McGregor, as I understood the first strand of the argument against you, and frankly the strand that I find potentially the most persuasive, it was based on the reasoning of Justice Scalia in Prince. How do you address that strand of the argument?
Yes, Your Honour. I note that our friends have relied upon United States case law to mount an argument that the imposition of duties on any state officer would breach the Melbourne Corporation principle, and we'd submit that this argument is mistaken for two reasons. To first turn to the suggestion that Australia should adopt an analogous approach to US case law such as Prince. This is misguided, and the court addressed this in the case of Austin. To quote from page 196, Your Honour, in the case of Austin, this court held much of the reasoning in Prince cannot be directly applied to the Australian Constitution. And the reason for this, Your Honour, is that the constitutional objectives, when we compare the US and the Australian system, are different. The court in the case of Austin emphasised the cooperative objectives under Australia's federal compact, and this is contrasted to the US system, which conceives the states as separate sovereigns. And this distinguishment means that this kind of case law cannot be relied upon or transposed into our Australian system with respect to the Melbourne Corporation principle. And secondly, Your Honours, I would note that there is a strong history within Australia of the Commonwealth requiring states to perform duties, including during crises. The first uniform tax case of 1942 co-opted personnel to collect income for the Commonwealth or state personnel in World War II. And I'd note that our friends' reliance upon the case of R and Hughes was misguided on this point in respect to their argument that the Commonwealth cannot affect state personnel. And that is because in the case of R and Hughes, that case concerned invalidity on the basis of the operation of Section 109 of the Constitution, and gave reference to the cooperative nature of that scheme in question. And Melbourne Corporation principles simply did not arise in that case. And so for those reasons, Your Honour, there is no general rule against co-opting state employees in Australia. To turn to a second point with respect to the management of personnel and Commonwealth legislation affecting this management. One key observation in the cases of Austin and Clark is that the Melbourne Corporation principle is only likely to apply where interference affects the higher levels of government. To quote Justices Gaudron, Gummo and Hayne in the case of Austin at paragraph 152, this class includes, and I quote, ministers, ministerial assistants and advisors, parliamentary officers and judges, and Victorian public health officers identified in Section 8 of the Cove Act do not form a class of persons that perform constitutional functions intrinsic to a state's existence. In the case of Re-Australian Education Union, at page 232, the assessment of persons going to the higher levels of government turns on, and I quote, the character and responsibilities of the employee. And when we turn to the character and responsibilities of public health officers, these are defined in Part 9 of Victoria's Public Health and Wellbeing Act. And those functions primarily pertain to relatively minor operations with respect to a state's constitutional structure. They pertain to the inspecting of premises and requesting and management of information related to public health risks. And critically, Your Honours, at no stage are they tasked with advising the Minister for Health or the Secretary to the Department of Health, and so cannot be considered ministerial advisors within the class of higher level personnel stated in Austin. I note our friends have raised the public health risk and emergency powers under Victoria's Act, for example, Section 199(1)(d). And our friends have relied upon these to state that executive powers, those executive powers are essential to the functioning of a state government. But when we look a little bit closer to the Act and those powers, there are two important observations to note. Firstly, that Section 200 bracket 9 makes clear that these powers are subject to the review of the Chief Health Officer. And also, I note that at Section 199, these powers are not automatically conferred on authorised officers under Section 30, but they must be additionally conferred by the Chief Health Officer, such that not all public health officers captured by the Cove Act would possess these additional powers. And so, Your Honours, because of the types of functions typically engaged by public health officers and the fact that these additional powers are limited, public health officers cannot be seen as falling within the class of the higher levels of government as contended by our learned friends.
I think that the argument for the plaintiff put a lot of weight on the fact that it was said the effect of Section 8 was to actually co-opt a state employee and not merely to affect terms and conditions. And it was for this reason that it was said to be an impermissible interference in state intergovernmental power. Is it relevant that the power under Section 8 requires the direction to specify the location and date and times at which the public health officer is to be present at the airport?
Yes, Your Honour, this does take me to the second factor pointing to validity in this case. And to first address your point with reference to the argument raised by our learned friends that Section 8 may allow the Commonwealth to co-opt potentially all public health officers. And with respect to that argument, we would say that this betrays, with respect, a fundamental defect in constitutional reasoning. That is, it is well established that the Commonwealth Constitution should not be construed by reference to, and I quote from paragraph 188 of the Work Choices case, extreme examples or distorting possibilities. And when we look to paragraph 19 of the special case, this legislation has currently only been employed to co-opt Miss Arnold and some other public health officers for a mere 8 hours. And so we would submit that the plaintiff's characterisation of Section 8 co-opting all public health officers is certainly extreme and should be avoided by this court in applying its reasoning.
To what extent, though, can we rely on the way in which the law has actually been applied, as opposed to the terms of the Commonwealth law itself, and in particular Section 8? That was why I directed your attention to Section 8, subsection 3, which on one view didn't allow an unlimited co-option, to use the plaintiff's term, of a public health officer.
Yes, Your Honour. And when we do look directly to Section 8, I would note that at Section 8, subsection 2, the Minister may direct a state public health officer. And the corollary of this is that it seems that a separate direction would have to be made by the Federal Minister for Health for each separate public health officer that is co-opted. And this would suggest that the practical capacity for the Federal Minister for Health to co-opt every single member of a state's public health officer service would be considerably unlikely, as that would require a great deal of effort from the Federal Minister of Health. And to address the second component of Your Honour's question with respect to how much emphasis we can place on the practical implementation of this Act as opposed to its scope, I'd note that in the case of Austin, at paragraph 124, this court held that the Melbourne Corporation analysis engages questions of form, substance, and actual operation. So all are relevant and form relevant parts of this multifactorial analysis. And so we'd submit the actual operation is relevant in that sense. And we would also concede that the potential substance is also relevant, whilst noting that this court should steer clear of extreme examples or distorting possibilities. And to address the breadth of Section 8 in general, we would note that Section 8 is limited in multiple regards in terms of its scope. First, as mentioned earlier, Section 8 only operates with respect to public health officers, and the Minister must specify dates and times, which does place some restrictions on the Federal Minister's power. And Section 8 is also limited temporally, requiring the declaration of a biosecurity emergency. And so for those reasons, Section 8 is limited in scope, again, indicating and pointing toward validity. Your Honours, to turn to the third and final factor pointing to validity in this case, and that is that Section 8 retains governmental choice with the states. The plaintiffs have failed to address this factor, which significantly favours validity in this case. As outlined at paragraphs 33 and 34 of our written submissions, Your Honours, Section 8 of the Cove Act retains state choice over the number and employment of public health officers. State choice is an important factor in favouring validity, as this court held in the case of Austin. And Section 8 preserves state choice when we look to Section 3 of the Cove Act, in terms of who constitutes a state public health officer, being entirely dependent upon state legislation. In fact, Your Honours, with respect to Victoria, the Commonwealth Minister's powers under Section 8 hinge entirely upon Section 30 of Victoria's Public Health and Wellbeing Act. And we would submit that Victoria remains free to choose the number of its public health officers, as if certain public health officers are co-opted by the Commonwealth, Victoria is still free to choose to employ additional public health officers or to simply redirect other employees to perform these functions. And this critical choice retained by the Victorian government is a factor strongly indicating validity, in that Victoria's independence as a government is retained. And so, Your Honours, noting my time, and if Your Honours have no further questions, I seek to leave this court with one final point. That is, this case boils down to the consequences of validity. If this court today holds Section 8 is valid, Victoria will continue to function as a state within Australia's constitutional system. And this being the very essence of the inquiry under the Melbourne Corporation Principle, suggests that Section 8 should be upheld by this court. If I can be of no further assistance to Your Honours, I rest my submissions here.
Thank you, Ms. McGregor. I thank, on behalf of the members of the court,